Jr., appearing there from the counseling center. All right. This hearing is being conducted by Zoom. His attorney is Jacob Wagner, appearing by Zoom. Also from his office is Assistant Prosecutor King. The defendant is charged along with 3 co-defendants with breaking and entering, theft, and impersonating a peace officer. This is a first pretrial, final pretrial set on the 10th of February, and trial is set on the 10th of March. I see that there was a discovery request filed just day before yesterday, so the state hasn't had a chance yet to apply with that, I assume. Or did you get a chance?
Actually, we complied yesterday, Your Honor.
Okay. All right, so the defense discovery will be due by the final pretrial. And do you anticipate any pretrial motions at this point, Mr. Wagner?
Not based upon my discovery review, and I did the prelim, so not at this time, Your Honor.
And has there been a written plea offer presented yet?
There has not been a written plea offer. Mr. Wagner and I have met and have discussed a potential resolution of this case.
Okay. All right, any other matters that we need to discuss in this case?
Only for Mr. I'm sorry. I had Mr. Means' phone number off the affidavit and see just for him to stay in contact with me should he be released from the counseling center, Your Honor.
Okay. How long have you been at the counseling center, Mr. Van Hoos?
This is my 7th day.
All right, so you should be there for the next few weeks then, okay. All right. Do you have his number, Mr. Way to get in touch with him, Mr. Wagner?
Not at the center, I don't, Your Honor.
Do you have a phone number there you can give him, Mr. Van Hoos?
Yeah.
It is 937-544-5218.
Got it. Thank you.
Thank you very much. Anything else said on this case?
There, Your Honor.
Okay, thank you. You can go ahead and log off then, Mr. Van Hoos.
Thanks, sir.
All right. Next case is Ralph Morrison. Case number 21 CR 186 and 21 CR 002. Both filed the same file versus Ralph S. Morrison. And you are Ralph S. Morrison appearing there from the jail. All right, Mr. Morrison is indicted in 21 CR 186 for failure to comply and received stolen properties in the first pretrial. Final pretrial set for the 26th and trial date is set for the 7th. I don't see any discovery in that case yet. Have you requested that, Mr. Wagner?
We requested it and we have it, Your Honor.
Okay. Well, it hasn't made it to the file yet, so, all right. Now, wait a minute, maybe I'm wrong when you actually had this. Oh, yeah, this was a case where we had referred Mr. Morrison for evaluation. All right.
Yes, sir.
Then in 22 CR 002, I just believe we ringed him the other day on that last week. So I don't see any discovery in that case. That's the domestic violence. Have you requested that?
We requested it, Your Honor, but again, likewise with Mr. Butler, I've met with Adam twice already, saw Ralph twice this week, so I'm well apprised of the situation.
Okay. All right. Any other matters that we need to discuss at this point?
No, sir.
All right. So this hearing is being moved up from your hearing set for Wednesday, Mr. Morrison. We have a real full docket, so Mr. Wagner agreed to get some of these cases moved up, so you won't be before me next Wednesday. This will take in place of that. Okay? Thank you.
Thank you, Your Honor. God bless you all. Have a good weekend. Mr. Wagner, can I see you as soon as possible, please?
I'll be back out, bud.
Yes, sir. Thank you, sir. Have a good weekend.
Okay. Now have Mr. Mock. Is Mr. Mock in custody?
Yes, sir.
Okay. He's not in custody in this case, though, is he?
He's got blues on. He's got a misdemeanor, like a drug instrument paraphernalia. That's the case being held on.
All right. I would say I didn't think we had him here. All right, this is case number 21 CR 131, State of Ohio versus Brian Anthony Mock. You're Brian Anthony Mock, appearing there from the jail.
Yes, Your Honor.
All right, this hearing is being conducted by Zoom. Mr. Wagner, you and your client both agree that this hearing be conducted remotely rather than having him appear personally in the courtroom.
We do, sir.
You're agreeing with that, Mr. Mock?
Yes, Your Honor.
All right, Mr. Mock, since you're not in the courtroom sitting next to your attorney, if you need to talk with him at any time during this proceeding, just tell me, and then I can put you and him in what's called a breakout room where the two of you will be able to talk, no one else will be able to see you or hear you. It'll be totally confidential, okay?
Yes, Your Honor.
All right, Mr. Mock stands charged in 2 count indictment of having a weapon under disability, receiving stolen property, then there's also a forfeiture, seeking support with weapon allegedly used in these counts of the indictment. Matter is set for pre-trial, I believe, next Wednesday, and at Mr. Wagner's suggestion, this matter be moved up to today. So I have been presenting Mr. Mock with a plea of guilty form, which says you're going to withdraw your not guilty plea and plead guilty to counts 1 and 3 of the indictment. This is a form, I'll hold up to you, this camera here, has your case number and your name, it says plea of guilty. So I'm going to hold that up to the camera, and you recognize that document that I'm holding up to the camera.
Yes, Your Honor.
All right, now on page 3, there are signature lines, and about a third of the way down, there's a sentence that says, I enter this plea voluntarily, and immediately below that, there's a signature line under which is put a signature defendant, and I see there looks like there's an X right at the beginning of that. I'll hold that up too. Is that your signature there that appears above Mr. Wagner's there next to my index finger?
Yes, Your Honor.
And when did you sign this document, Mr. Mock?
I signed this document today, sir.
All right, and Mr. Wagner came out to the jail and went over with you,
Yes, I already did.
and he explained that to you and answered any questions you had?
Yes, I already did.
And do you feel you had enough time to fully consider this matter before making this decision to sign this document?
Yes, Your Honor, I believe so.
And are you entering into the agreement to plead guilty in this document voluntarily?
Yes, Your Honor, I will.
All right, now the agreement states that you're going to withdraw your not guilty plea, plead guilty to the charge of having a weapon under disability, under section 2923.13A3 of the Ohio Revised Code, which is a third-degree felony. And it also says you're going to plead guilty to count 3, the forfeiture specification under 2941.14.17 of the Ohio Revised Code. Now, states that you understand that the maximum penalty for count 1, the weapon under disability, could be 36 months in prison. If the prison term imposed, the minimum would be 9 months. It would be different levels in between. There's a fine available of up to $10,000. With regard to count 3, there's no financial sanction or any jail time, prison time, but it would result in the loss of any rights that you might have to the property that's being forfeited. That's listed in count 3. Do you understand that?
Yes, Your Honor.
Mr. Mock, are you facing any felony charges in any other jurisdiction at this time?
No, Your Honor, I'm not.
Are you currently on probation, big control, parole, or post-release control supervision for a felony?
No, Your Honor, I was just on probation for when I was out on bond.
Yeah, okay, pre-trial supervision. Okay,
Yes, Your Honor.
all right. Now, under the law, Mr. Mock, if you are convicted of this offense and sentenced to prison, once you complete the prison term imposed by the court, it is possible that the adult parole authority might choose at their option to place you under post-release control supervision for a period of up to 2 years. The court's not involved with that. That's strictly their decision. If they decide to do it, you'll be supervised in the terms that they set by a parole officer. And if they determine during that period of up to 2 years that you have failed to comply, then they could return you to prison even though you served the entire term set by the court for an additional period of up to 9 months for one violation, but there would be a cap of half of whatever prison term is imposed by the court for all violations. However, if you are convicted of a new felony while under post-release control supervision, in this case, then in addition to whatever sentence the judge in the new case would impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year, or whatever time might be left on the post-release control term, whichever is greater. If that occurs, that has to be served consecutively as sentence in the new case. Do you understand that?
Yes, Your Honor.
Now, under the law, I'm not required to sentence persons convicted of this offense to prison. You can't impose what's called non-prisoner community control sections. And that means that instead of going to prison, you would be put under the supervision of a probation officer for a period of up to 5 years and a term set by this court. If during the period of time that you were being supervised, the probation department felt that you were not complying, they would file a written allegation of that with the court. You would be served a copy of that. There would be a hearing in front of the court, and you would be entitled to have an attorney at that time. If the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and then sentence you to prison for between 9 and 36 months under the increments provided by law in a bond of $10,000. Do you understand that?
Yes, Your Honor.
Now, the charge in count 1 alleges that on or about June 1, 2021 in Highland County, Ohio, that you not having been relieved from disability as provided under ORC section 2923.14, did knowingly acquire, have, carry, or use a firearm for dangerous ordinance, to wit a Chiapa 1911-22, serial number 13C45083, that you were either under indictment or have been convicted of an offense involving the illegal possession, use, sale, administration, distribution, or trafficking of drug abuse, and I'm going to leave out the part that's not applicable, to wit, possession of heroin in Highland County Police Court Case number 16 CR 0139 on May 18, 2017. So that's the charge of having a weapon under disability under 2923.13A3, the third degree felony. Then count 3 alleges that on or about June 1, 2021 in Highland County, Ohio, you had your possession of that weapon I just mentioned is subject to forfeiture due to its instrumentality in the commission or facilitation of the offense. All right. Now, Mr. Mock, do you understand what it is the state says you did in each of these 2 counts, when, where, and how they led you did it?
Yes, Your Honor.
Do you understand the possible penalty for count 1 as far as prison and fine, and then count 3 to be the loss of the property?
Yes, Your Honor.
Now, have you discussed the nature of these charges, the evidence in the case, possible legal issues in the case, possible defense you might try to raise at trial, possible outcomes of a trial with your attorney?
Yes, Your Honor.
And are you satisfied with his advice and confidence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Are you taking any prescription drugs at this point?
No, Your Honor.
Have any threats been made to make you plead guilty here today?
No, Your Honor.
Now, on page 2, there are 3 lines that are printed in bold and underlined in this agreement that I'm looking at that you signed. So I'll read those at this time. It says, they say, quote, defendant shall enter a plea of guilty to count 1 and count 3, state will dismiss count 2, state defense jointly recommend community control of star, defendant agree to torture outline in count 3. That's the end of the quote. Now, is that your understanding of the agreement?
Yes, Your Honor.
Does anyone promise you anything other than that to get you to plead guilty here today?
No, Your Honor.
Now, under the law, the court's not required to follow a plea recommendation as to sentence. So, if you plead guilty, I'm not required to give that sentence. Once I've heard all the information that's presented to me, if I feel that's not the correct sentence, I could sentence you to prison for between 9 and 36 months in the increments provided by law, and or fine you $10,000. You understand that?
Yes, Your Honor.
Now, Mr. Mock, do you hold any license or certification from any state governmental agency that regulates any kind of a profession?
Your Honor, I just have college credentials in St. Clair for telemarketing customer service in Oakland.
That's I believe that's a trade certification, though. It's not a state license, is it?
Right.
Yeah, it doesn't come from the government there. Okay. Okay, now you have certain constitutional rights, which I understand, Mr. Mock, before I can accept the plea of guilty. First of all, you have a right to counsel. Mr. Wagner's been appointed to represent you, not simply to work the case out, but provide any defense that could be available to you under the law that you would like to provide. And so if you decide you do not want to plead guilty, that you want to defend against this case, and he'll continue to represent you, to defend you, including a trial if that's what you want. You understand that?
Yes, Your Honor.
Right, now, Mr. Mock, under the Constitution, you have a right to have a jury trial in this matter, which means that 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. Once 12 of those folks are selected, the evidence will be presented, they've been instructed on the law, and then that jury would have to decide a jury of 12 would have to decide by unanimous verdict, meaning all 12 would have to agree as to whether or not the state proved your guilt of the charge. Now, if you did want to have a jury trial, but you did not want to plead guilty, you could waive in writing, and that means to give up your right to have a jury trial. And in that case, then you can have what's called a court or bench trial, meaning the judge would be the one who would hear the evidence instead of the jury. The judge would apply the law. The judge would decide whether or not the state proved your guilt by proof beyond a reasonable doubt. Do you understand that?
Yes, ma'am.
All right, now, under the Constitution, Mr. Mock, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that may be present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination. And the purpose of that would be to bring out evidence that helps your side of the case. Do you understand that?
Yes, ma'am.
And under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, your request, the court issues court orders called a subpoena. And that would force those witnesses to come to court and be available to testify if you wanted them to, even though they didn't want to be here. And that's the same way that the state's witnesses are forced to come into court to testify against you. You understand that?
Yes, ma'am.
All right, under the Constitution, Mr. Monk, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. Prosecutor can, the judge can, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation, which is if there's a jury trial and you do not testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, ma'am.
All right, now under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. What that means is that the burden of proof isn't on you to try to prove that you're not guilty simply because you've been accused of this crime. In fact, under the law, you don't have to present any evidence at trial in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of each offense by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, ma'am.
All right, now, Mr. Mock, originally he entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and yet exercise or revoke all the rights that I've just described for you. Now, if you change your plea from not guilty to guilty, that is the opposite of not guilty plea. Guilty plea admits allegations in the indictment, those two counts of the indictment, admits that they're true, that you committed those offenses. And that plea, as to those two counts, would waive and give up all the rights that I have explained for you here this morning, except one, your right to have counsel. You always have a right to have an attorney to represent you no matter what your plea is, but with that exception, your plea of guilty waives gives up the right to have a jury or court trial. The waives gives up the right to confront witnesses against you and cross-examine them through your attorney. The waives gives up the right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state. The waives gives up your privilege against self-incrimination, because if you say you're guilty, then that's what you find you guilty. The waives gives up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. Now, plea of guilty also waives gives up your right to file an appeal of any alleged violation of your rights you feel could have occurred until this point in the case. Now, should I sentence you to the maximum sentence, or under other certain limited circumstances, you can file an appeal. Any appeal you want to file would have to be filed within 30 days from sentencing after it being filed. And finally, a plea of guilty does subject you to being sentenced immediately by the court, but I think that is what should happen. You understand all of that?
Yes, Your Honor.
Mr. Mock, are you a U.S. citizen?
Yes, Your Honor.
Now, do you have any questions about the charges or the possible penalties or consequences for each of those two counts?
No, Your Honor.
You understand?
Yes, Your Honor.
Do you have any questions about the plea agreement?
No, Your Honor.
You understand?
Yes.
Again, you understand the recommendation on sentencing is not binding on the court.
Yes, Your Honor.
You have any questions about the constitutional rights I've explained?
No, Your Honor.
You understand those?
Yes, Your Honor.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, Your Honor.
You understand that?
Yes, Your Honor.
Now, is there anything you'd like to speak to Mr. Wagner about, confidentially before we go any further?
No, Your Honor.
Do you have any questions, about anything that I've explained to you here this morning?
No, Your Honor.
Then it is your decision, Mr. Mock, to withdraw your non-guilty plea to counts 1 and 3 and enter guilty pleas to those 2 counts in accordance with the terms of the written plea agreement that I've just gone over with you.
Yes, Your Honor, that's my decision.
All right, then as to count 1, which alleges, I'm only going to read the part that's factual, that on or about June 1, 2021 in Huntington County, Ohio, you did not, having been released from disability provided in ORC section 29.3.14, to knowingly acquire, have, carry, or use a firearm or dangerous ordinance to wit a shop at 1911-22, serial number 13C450A3, and that you had been under indictment or been convicted of an offense involving the illegal possession, use, sale, administration, distribution, of trafficking in a drug of abuse, to wit possession of heroin in Huntington County Home Police Court case number 16 CR 0139 on May 18, 2017. In violation of section 2913.13A3 of the Ohio Revised Code, the charge of having a weapon while under disability, third-degree felony carrying a possible prison term between 9 and 36 months in the increments provided by law and a fine of up to $10,000. How do you plead?
I plead guilty, Your Honor.
As to count 3, which alleges that on or about June 1, 2021 in Huntington County, Ohio, you had in possession a shop at 1911-22, serial number 13C45083, subject to forfeiture due to its instrumentality in the commission or facilitation of the offense, as defined in section 2941.14.17 of the Ohio Revised Code, which be a forfeiture specification which would result in the loss of any rights to that weapon to the state of Ohio. How do you plead?
I plead guilty, Your Honor.
All right, the court finds that on this day, no, the court defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Rule 11. Please accept it or filed. Defendant is found guilty of each offense. Counts 1 and 3. Count 2 is dismissed. The court will order a pre-sentence investigation, which shall include an assessment for substance use and/or mental health assessment, and a STAR evaluation is ordered. Sentencing will take place on March 2, I believe. Yeah, March 2nd. At 9 a.m. That will be in person. And your bond in this case is continued. I understand you're in custody because of a misdemeanor. So if you finish that term before the 2nd of March, you need to report to probation when you're released. And they'll be in touch with you while you're still. How long have you got to be in jail? You know?
For my municipal?
Yeah.
I'm not sure yet, Your Honor. I haven't been back in court yet.
Okay. All right. Well,
I do have a bond, but if I need to stay in here without a police until my sentencing, then my people would bond me out if possible.
yeah. Well, you're on bond on this case. You're not being held in this case. You're being held in that case. So what I'm saying is, if they don't get in touch with you before you get released, you get to the probation department, immediately. If it's after business, by the end of business day, if it's after 4 o'clock, then the end of next business day, so that they can get your pre-sentence report started, and you're still required to be reporting to them and so forth. And I'll have to say that there was a notification that your reporting in this case has not been very good. The last report I had, December 17th, indicated that he hadn't been at the scene since October 28th, and so you need to. And I know we had some issues with you getting reporting for your forensic examination. So,
yes,
if you want to get community control of the STAR and not go to prison, you need to be reporting and being on your best behavior between now and your sentencing. All right. Anything further from counsel?
No, Your Honor.